Today we're going to begin the discussion of criminal law. Criminal law is important, but it is completely different from civil law. We have a different body of parties, we have different objectives, and although there is some crossover where the same act can constitute both a civil action as well as a criminal one, as we'll discuss in a few minutes, they really address different things. Civil law will address torts, which we have discussed so far this semester, as well as contract law, which we will go into next section. And criminal law will deal with offenses that are viewed as an offense committed against society as a whole. Some of the things that are important to note are that there are some differences in the parties on each side. Whereas you may have a defendant in a civil action and a criminal action as well, in a civil action you're going to have a plaintiff, the victim of the alleged harm that was caused by the wrongdoer or the tortfeasor. In criminal law, although there is still a victim, the victim is not the party who brings the prosecution, but instead it is the governmental entity, whether that be state or federal. Next thing that I think is very important is that there is a difference in burden of proof. In civil law, we have a burden of proof known as a preponderance of the evidence. I like to picture the television commercial when I think of preponderance of the evidence, where you had two vehicles pulling up next to each other and one of them rolling down the window and saying, "Pardon me, sir, do you have any gray poupon?" As if preponderance of the evidence or some brown mustard was something very special. Preponderance of the evidence means very simply more likely than not. If you were going to actually quantify preponderance of the evidence, you can actually do so. It means something more than 50%. If you are looking at the scales of justice and you see the scales of justice exactly even at the beginning, then in order for a plaintiff to carry the burden of proof, they must tilt those scales of justice ever so slightly in their favor. More likely than not, 50 point something percentage likely that they were correct, and that would constitute carrying the burden of proof by a preponderance of the evidence. In criminal law, we've all heard this before. Unlike a preponderance of the evidence, we've heard the term guilt proven beyond a reasonable doubt. And beyond a reasonable doubt is somewhat of a fuzzy concept. It is deemed to be an objective concept in the law, that is one that you can determine, but beyond a reasonable doubt may mean something different in your mind than it does in my mind. It means something that a party can feel like they have some doubt, but it just must not rise to the level of being a reasonable doubt. The example I like to give is that a person is accused of robbing a convenience store, and there's an eyewitness that says that the robber was a white male wearing a red shirt and blue jeans and tennis shoes that had that were blue Nike tennis shoes. They went off in a gray sedan. And at trial, it's proven that the defendant was there at the time, white male wearing the same color shirt, blue jeans, and the tennis shoes were the correct color, but they were Adidas rather than Nike. Hopped into his gray sedan and left with the cash that he took while robbing the convenience store. The likelihood is that the difference between the Nike brand tennis shoes and the Adidas brand tennis shoes would not necessarily rise to the level of being a reasonable doubt. There's some doubt because there's a difference between Nike and Adidas tennis shoes. But was that enough? Is that enough to cast doubt on the eyewitness testimony? And maybe it is, but maybe it is not. On the other hand, if the defendant was a black female wearing a sundress and driving an SUV, then the likelihood is that there were all kind of reasonable doubts as to that eyewitness testimony, and they should be found not guilty. It is important also to know that you can't quantify reasonable doubt. Unlike preponderance of the evidence, where we said it was something more than 50%, we can't say that beyond a reasonable doubt is 75% or 80% or 90% or 99%. It's something, but it's beyond what a preponderance of the evidence is. We know that, but it does not lend itself to a precise mathematical formula. There have been some interesting cases recently in which a burden of proof played a large part in determining the guilt or innocence, I should say the guilt or not guilty verdict. You don't find a defendant innocent, you find them guilty or not guilty in a particular circumstance. Years ago, we had the O.J. Simpson case. You may remember, if the glove does not fit, you must acquit. And O.J. Simpson was found not guilty of the crime of murdering two individuals, his ex-wife and a friend. On the other hand, he was found subsequently to be liable civilly for the wrongful death of both parties. And the reason for that is those are not inconsistent, but they instead use a different burden of proof. In criminal law, they had to prove that he was guilty beyond a reasonable doubt. The glove, the testimony of one of the investigating detectives that was shown to exhibit racist tendencies and some other things cast a doubt on the guilt of the party, and the jury determined it was a reasonable doubt and that they could not decide that the prosecution had found him guilty beyond that reasonable doubt. On the other hand, in a civil case, the juries there determined that it was more likely than not that he did, in fact, commit the killings and was responsible for the deaths, the wrongful deaths of the parties. So it's a different burden of proof. It's a different standard. One is lower than the other. It's also important to note beyond a reasonable doubt is a very precise legal standard. Do not confuse this with something like beyond all doubt or beyond a shadow of a doubt. There was a case involving Casey Anthony a few years ago, and I read an article that said that the jury there was confused, that they may have been confused and confused the common sense, everyday language of beyond a shadow of a doubt with the legal standard of beyond a reasonable doubt. We've all used that term before. Well, I just know that he did this beyond a shadow of a doubt. He did it. That's different than beyond a reasonable doubt. Beyond a reasonable doubt, again, permits something to exist, some sort of doubt to exist, as long as it's not beyond, or as long as it does not rise to the level surpassing what a reasonable doubt may be. Last thing I want to mention on the PowerPoint slide 3 is the remedy. In civil law, we've discussed compensatory damages and punitive damages, mainly as the two type of damages that are awarded. Compensatory damages are awarded to compensate a victim for the harm that has occurred, and punitive damages are damages that are designed to punish the wrongdoer and to deter the wrongdoer and others like the wrongdoer from engaging in similar intentional wrongful conduct in the future. Criminal law is more of a punishment type of concept, in which the remedy is designed to punish the wrongdoer for the the wrongful action that they took. So in this way, it actually is a similar concept to that of an intentional tort. In order to convict a defendant of a crime, you have to show two things, generally, beyond a reasonable doubt. One is that it must be a voluntary act. That's actus reus, an illegal act that was committed voluntarily. And secondly, that they did so with an evil intent, mens rea, that they had a specific intention to engage in the wrongful conduct. Without actus reus and mens rea, as a general rule, you cannot convict someone of a crime. Here's an example shown of a person being attacked physically, and the same action as in the O.J. Simpson case can constitute both a civil wrong or a tort as well as a crime. I have mentioned in class a case that I handled once concerning someone who was attacked at the River Chase Galleria parking deck. And that action, in that action, the party that did the attacking was arrested and charged criminally with assault and battery type concepts, and then he was also sued civilly for battery, physical battery, as well as an intentional tort, and in fact was found criminally liable and settled the case, but would have been found liable for the tort as well. We've mentioned this before, and that is that a corporation is not a box, it's not a thing, but it's actually a living, breathing sort of animal. I like to talk about corporations in terms of them acting with and through their people. We have discussed in class a lawsuit involving McDonald's Corporation, and we discussed how McDonald's Corporation presented itself at trial through the testimony of its experts, its quality assurance manager, etc. And that is the face of the company. Well, in the law, we actually find that a corporation is not only acting through the people that represent them, their officers and employees, but they are also considered a legal person, and they have certain rights and protections and responsibilities just like a person may have. They can be fined criminally or lose privileges. A few years ago, there was a club in Southside, Birmingham, that had some criminal activity, and they had their license pulled. License to conduct business as a club is a privilege, and that privilege can be withdrawn in the event that criminal activity is deemed to have been found, and that was the case in that situation. And then we also have again, acting with and through their people, corporations can be found criminally liable or criminally responsible by finding their officers and directors criminally liable and criminally responsible. And we have an excellent example of that here in Birmingham, Alabama. I know that everyone here is familiar with the Health South case, and Health South was charged with committing fraud, fraudulent financial statements, and defrauding their investors through various manipulation of financial statements and the like. And in fact, there were some officers and directors and employees of the corporation that actually went to jail or were fined or placed on probation, etc., as a result of that kind of activity. We have a number of different types of crimes, and we're going to go into them specifically. I think the difference in a violent crime and a property crime is pretty self-explanatory. White-collar crimes are crimes that are deemed to be not physical in nature as much as embezzlement and stealing things, committing fraud, etc. And you see some more listed here. RICO, I want to stop for a second and mention RICO. RICO stands for the Racketeer, that's Racketeer, Influenced, and Corrupt Organizations Act. It was the mob busting statute, a mafia type of law. And I like to remind people here and ask them if they know what crime Al Capone actually went to prison for. And some of you probably know that Al Capone was actually charged with tax evasion, and that's what ultimately put him behind bars. RICO is kind of the same sort of thing. It is designed to attack racketeer activity, mafia type of activity, and it is an interesting statute. It's interesting because it applies both criminally and civilly. There are specific criminal provisions related to RICO in which someone found to have violated the statute can be put behind bars. And there are some civil responsibilities as well, holding them liable for damages up to treble damages or triple the amount that is proven, and attorney's fees. There are some sleazy plaintiff lawyers who have used the RICO statute to pursue various claims in civil cases in which you generally would not have thought it probably applied. I saw one case where a bank was sued for violating RICO as it related to certain activities the bank was engaged in. I saw another case in which you had a credit collector, a collection agency, sued along with their clients for allegedly illegally adding on fraudulent amounts to the amounts that they were collecting. They asserted that it was done in concert together, there was an enterprise, etc. RICO law is a very complex area, and certainly we're not going to need to know all the intricacies of it, but I do want you to know the basics of RICO, kind of what it stands for and what it means. Generally speaking, crimes are divided into two sections. There's either a felony or a misdemeanor, and the difference, very simply, definitional difference, is very simply a dividing line. If you can be punished for more than 1 year, it's a felony. If it's less than a year, it's a misdemeanor. And it doesn't have to do with what they were ultimately convicted of and sentenced to. For example, there was a case involving a Stanford swimmer just a few weeks ago, at the time of recording this, in which he was found guilty of a sexual assault on an unconscious, intoxicated woman. A rape type of conviction. It was a felony. It is a felony. It is punishable by death or prison for more than 1 year, although he was sentenced to a 6-month term. That doesn't make it a misdemeanor. It's still a felony. The fact that he received less than the maximum amount doesn't change the nature of the crime. We're going to discuss a couple of defenses to criminal liability. One of them is infancy. You remember we discussed a few minutes ago the fact that for a crime to be proven, you have to show two things. One, that actus reus, a voluntary act, took place, and two, that mens rea, or an evil intent, existed at the time of the evil action, at the time of the voluntary action. And if you think about it, the first defense here makes sense. A juvenile, someone too young to appreciate the wrongfulness of their conduct, may not have the ability to have that mens rea, or that evil intent. One of my earliest memories, many years ago, is when I was a very, very small child. I must have been 4 or 5 years old. And I recall my mother sending me back into a grocery store to pay for a candy bar that I had taken. Certainly a 4 or 5-year-old is not going to be charged with the crime of theft for stealing a candy bar from a grocery store. 4 or 5-year-old sees the candy bar, takes the candy bar, doesn't understand the concept of it belonging to someone else and needing to pay for that, although my mother certainly did. She also exerted her own method of criminal punishment, as I recall. But in any event, beyond a certain age or below a certain age, the law will deem you incapable of forming that evil intent. Involuntary intoxication is a very rare type one. It is not that, oh my gosh, I was so drunk I can't be held responsible for what I did that night. No, that's not involuntary intoxication. The fact that you drank more than you expected to, that you didn't hold your liquor, that whatever, is not cause for the involuntary intoxication defense. It is only a defense if someone was intoxicated through means that they didn't cause themselves. If someone slipped you something into your drink, etc., then perhaps. Insanity is the one I want to focus a little more time on, and that is that criminal insanity defense is one that actually has different standards depending on the jurisdiction, and sometimes depending on state versus federal law. You have a bunch of different tests. One of them that Alabama uses is called the Monotone test, and that is that the defendant lacked the ability to understand the difference between right and wrong, that he did not understand that his conduct was wrongful, or if it was right, or what the difference between the two may be. Federal law sometimes imposes an irresistible impulse test, that the defendant knew the conduct was wrongful but was powerless to stop their own actions. They could not resist the impulse to commit the act. There was a case in Texas years ago involving a mother who drowned her children, and as I recall, the defense in the case was that heard voices that told her she must do it. She could not resist those voices, didn't have the power to resist those voices. Even though she knew it was wrongful, she was unable to resist that type of impulse. And that would have been a successful defense in jurisdictions that use that as an insanity type of defense. Mistake, I just want to briefly mention, can be a defense. And if you think about it, it also relates to the very essence of what we've talked about. You've got to prove these things beyond a reasonable doubt, but you've got to prove two things. One is that there was a voluntary act, actus reus, and also that an evil intent, mens rea, existed. If you thought it was your car or your phone that you picked up and you took it, then that's not stealing because you didn't have the requisite intent. It was a mistake. So mistake really means that you didn't fulfill one of the two requirements necessary to show that a crime has been committed. Consent is also a very easy one. Let's say that you have two individuals that are involved in a boxing match. It's a Golden Gloves boxing competition, and one of the two beats the other one up. And the one that's beaten up wants to have the first one arrested for battery because they have just beaten them to a bloody pulp. Well, unfortunately for that party, they can't hold them either criminally or civilly responsible because they have consented to the conduct of being struck in a boxing match. They have basically assumed the risk of being hurt by being beaten up. There was, at the time of recording this, Muhammad Ali recently died, and he had been suffering from Parkinson's disease for more than 20 years, more than 2 decades. And the doctors have said that it was as a result of being struck in the head something like 20,000 times. Don't hold me to that number. That's what I recall. Muhammad Ali was an outstanding boxer, maybe one of the greatest of all time, maybe the greatest of all time, but he certainly was hit and struck because he consented to the conduct of being placed in the ring with someone trying to defeat him in the boxing competition. So the same thing would apply. He would neither be able to charge them criminally or civilly for their actions because he consented to the activity. I'm going to mention the one here at the bottom first, or I should say almost at the bottom, the statute of limitations defense. To me, this is the very best defense you have in any circumstance. If you have, say, 1 year to charge someone with violating a statute, a criminal statute, and you wait 1 year and 5 days, then the statute of limitations has expired. They may have committed the crime, but they're not going to do the time because the statute of limitations has expired. It's a whole lot better than I didn't do it defense or any of the other defenses that we're talking about, because this one's cut and dry. Very few in the law are, but this one's cut and dry, that in the event, it's a bright line test, in the event that they have not been charged with the crime within the requisite period of time, then the statute of limitations expires and they are powerless to hold them criminally responsible. Moving up, we have entrapment. You read this, you see this on TV a lot. In real life, very seldom is it successful. Entrapment requires a lot of things to occur. It requires the other party to have suggested the crime. It requires the other party to have been the initiator of the conduct. It requires the alleged or the defendant not to have had the crime in mind when they engaged in the conduct. I saw a case once in which a drug dealer was charged with drug dealing. He had been approached by the undercover agent weeks beforehand and declined to sell the undercover agent drugs. And the undercover agent continued on a daily basis, very persistently, trying to get him to sell him drugs. Finally, the drug dealer complied, and when he did, the drug dealer was arrested, and he claimed entrapment. And the case there found that entrapment was not successful, even though the other party had suggested the crime, that he still would have committed the conduct anyway, and that it wasn't an ordinary person that was not already predisposed to have committed that type of conduct. So you can see that it is very, very seldom that is going to be successful. The last one that I want to mention is the justifiable use of force. And there are a couple of very important things that I want to mention here. First thing is, the law allows the use of reasonable force to defend yourself. And what is reasonable under the circumstances depends upon the circumstances. For example, in the event that someone is coming at you with a knife, can you pull out a concealed weapon gun and shoot them? The law says that you can. You are entitled to use deadly force if you have a reasonable belief that you are in imminent harm or imminent, you may receive imminent death or serious bodily injury. There was a case involving this a few years ago in North Birmingham, where a convenience store owner was tired of his convenience store being robbed, and so he set up a spring gun, so that if someone came into the store after hours, opened the door, jimmied the lock, the gun would go off and shoot the person. The law says you cannot use deadly force to protect property alone. That is an improper use of force. That is not a defense to criminal liability. So the store owner could be held liable for murder in the case of killing a burglar who came in after hours if no one is there and he's not protecting himself or others. It's very important. There was a case in Shelby County a few years ago in which a burglar entered a house, and the homeowner or the homeowner's grandparent, as I recall, came back and scared them off. And as they were heading down the road in their car driving away, trying to get away, the grandfather shot at them with his shotgun. And the question there is, can the grandfather be held criminally responsible? And the answer is yes. Maybe surprisingly, but at that point, he's using deadly force to protect property or to retrieve property, if you want to view it that way. And you can only use deadly force if you are in reasonable belief that you're going to receive death or serious bodily injury. It is a personal type of defense that applies to you or to someone else. You see someone breaking in, holding a knife to your spouse, and they're not holding the knife to you. Can you shoot that person? Yes, you can. You can do so. You can use deadly force to protect that person as well. It's called self-defense of others. Duress, I do want to mention duress, and duress actually applies when a party is extorted or placed under physical harm, threat of physical harm, illegal threats are made, and they are caused to do something that they would not ordinarily have done. The law says that duress will never suffice to justify a murder. So if someone's holding a gun to your head and says, I'm going to pull the trigger unless you shoot someone else, then the law says that you must not shoot that other person and be shot yourself. On the other hand, if they say, I'm going to shoot your spouse unless you steal money from your boss, then the stealing money from your boss or the embezzlement that occurs may be subject to the defense of duress. And that's all we got for the first part of criminal law. Stay tuned for the more exciting second portion in a subsequent audio lecture.